Yeah, I think we are online. Let me put some people in. There might be some more people getting in, but firstly, I will need to put the link of our YouTube on the group, so people will. Yeah, here we are. Firstly, thank you, team, for joining us today in our weekly live talk show. It's our great pleasure having you, very prominent practitioner and speaker. We are very pleased to have today's live stream topic is the IBA rules on taking of evidence and the applicability of the IBA rules in Vietnam. I think firstly, I will need to speak in Vietnamese. For most of the audience, they are more convenient with the Vietnamese to have a background of the situation. And then I will introduce you and ask you to give some knowledge and sharing on the IBA practice internationally and in particular Singapore. And then we will have some time discussion on the possibility and the maybe difficulties and also the perspective, the outlook of the IBA rules in Vietnam. Is that okay for you, Tim?
It is. Thanks so much, Tony.
Yeah, I'm going to give a lot of complimenting introduction of you in Vietnamese. All good things, so don't worry. Xin chào tất cả các bạn. Hôm nay thì chúng ta cùng nhau lại ngồi lại ở đây trong một cái không khí là cũng hơi căng thẳng trong cái tình hình dịch Covid, đúng không ạ? Là nó đang bùng phát ở tại Việt Nam và chúng ta rất may là chúng ta vẫn có cái vì cái dịch Covid này nên chúng ta vẫn có một cái platform để có thể trao đổi, chia sẻ, nói chuyện với nhau mà không cần phải gặp nhau hoặc là không có bị giới hạn bởi Covid. Và các tuần trước thì chúng ta đã được tham gia rất nhiều các cái buổi nghe tất cả các cái diễn giả rất là nhiều kinh nghiệm, rất là nhiều kiến thức, trao đổi về các vấn đề khác nhau. Thì hôm nay chúng ta sẽ tiếp tục trong cái khuôn khổ của cái chuỗi hàng tuần sau cái kỳ nghỉ lễ mùng 1 tháng 5 và 30 tháng 4 để chúng ta cùng trao đổi với nhau một cái chủ đề hơi mới lạ một tí đối với cả các cái practitioner Việt Nam. Đó là IBA Rules on Taking of Evidence. Tiếng Việt là chúng ta tạm dịch là các cái quy tắc của IBA. IBA là cái tổ chức quốc tế về luật. Và cái tổ chức này thì họ có những cái bộ nguyên tắc trong đó có IBA rules và IBA guidance, rất là nhiều các cái bộ nguyên tắc. Riêng về đối với trọng tài thì họ rất là mạnh, và những cái bộ nguyên tắc của họ, những cái hướng dẫn của họ đã trở thành những cái luật mềm mà có cái tầm ảnh hưởng, theo đánh giá của cái báo cáo của trường Queen Mary, là cái tầm ảnh hưởng của nó xếp thứ nhì sau các cái tổ chức về institution như là SIAC hay là Hồng Kông IAC hay là ICC. Tức là cái tầm ảnh hưởng của các cái bộ nguyên tắc của IBA nó khiến cho các cái hoạt động trọng tài quốc tế nó được thông suốt, và nó tạo ra một cái platform để cho tất cả mọi người cùng có thể nói chuyện với nhau trong cùng một cái ngôn ngữ. Thế thì đối với cả cái IBA Rules on Taking Evidence là cái bộ nguyên tắc chuyên về việc là lấy chứng cứ, thì nó là một cái điều mà rất là mới đối với cả pháp luật Việt Nam. Và vì vậy cho nên là chúng ta nhìn vào cái vấn đề này, chúng ta nhìn với cả cái góc nhìn là chúng ta xem ở quốc tế người ta đã làm những gì với cả cái IBA Rules on Taking Evidence, và các cái kinh nghiệm quốc tế như sắp tới sẽ được ông Timothy đây chia sẻ, nó sẽ cho chúng ta thấy được là cái tác dụng, cái tầm quan trọng của nó và cái ý nghĩa của nó nếu như chúng ta có thể áp dụng được tại Việt Nam. Và hiện nay thì nó đã được áp dụng tại Việt Nam chưa, và nếu được áp dụng thì nó đã được áp dụng như thế nào, thì tôi có thể là sẽ trước khi mà đi sâu vào trao đổi với cả cái chuyên gia của chúng ta ngày hôm nay là Timothy Cook, thì lát nữa tôi sẽ có một cái background ngắn gọn về vấn đề này. Trước hết thì xin giới thiệu với tất cả các quý vị các bạn ngày hôm nay cái diễn giả được mời của chúng ta hôm nay là ông Timothy. Thì ông Timothy là luật sư của công ty Reed Smith. Ông là luật sư thành viên mà có cái kinh nghiệm rất là lâu năm về trọng tài, và không chỉ có kinh nghiệm lâu năm, ông là một người barrister về trọng tài, là một trạng sư ấy. Và ông cũng là một nhà nghiên cứu về trọng tài. Ông viết rất là nhiều các cái tác phẩm mà có lẽ là chúng ta nếu như mà đã từng làm trọng tài quốc tế thì chúng ta sẽ biết rất nhiều. Ông là ông là tác giả của cái cuốn Singapore Arbitration Book tên là International Arbitration in Singapore, Legislation and Materials. Nếu mà các anh chị các bạn mà có tranh tụng ở tại SIAC hoặc là tại các cái trung tâm trọng tài ở Singapore thì chúng ta sẽ hầu như là ai cũng sẽ phải có lúc xem qua cái cuốn này, thì nó là một cuốn sách rất là comprehensive về cái trọng tài, tranh tụng trọng tài tại Singapore. Và ngoài ra thì ông cũng tham gia vào trong rất là nhiều các cái việc viết các cái sản phẩm như là cái Chambers Asia Pacific về Singapore, và các cái sản phẩm về ví dụ như là nếu tôi không nhầm thì ông cũng có viết về cái protocol về hot tip conference của các cái chuyên gia trong tranh tụng quốc tế. Ông cũng là đại diện trong cái SIAP representative để thực hiện cái việc viết đó, bởi vì cái đấy là sản phẩm của SIAP. Và ông có rất nhiều các cái kinh nghiệm ở châu Á và cả của Việt Nam. Ông cũng là một trọng tài viên, cũng có tham gia một số các cái vụ kiện ở Việt Nam, và ông là một luật sư được rank trong cái dispute ở Legal 500 và trong cái benchmark litigation rất là liên tục trong nhiều năm, là một litigation star. Và arbitration được rank rất là cái hạng cao, như là một cái leading arbitration council ở trong Legal 500 Singapore. Hôm nay thì chúng ta sẽ nói về IBA rules, về cái bộ nguyên tắc của IBA về taking evidence. Thì tôi nghĩ là ông Timothy có rất nhiều các cái kiến thức về cái vấn đề này, bởi vì là vấn đề lấy chứng cứ là một vấn đề gần như là không thể thiếu ở trong tất cả các cái trọng tài quốc tế, và chúng ta sẽ có thể được nghe chia sẻ rất nhiều về cái cách thức mà lấy chứng cứ và cách thức đánh giá chứng cứ căn cứ theo các cái quy tắc của IBA. Hiện nay thì tôi xin nói sơ bộ về cái background của cái vấn đề về chứng cứ ở tại Việt Nam, ở trong cái tố tụng trọng tài Việt Nam. Lẽ ra thì nếu nói về cái này thì có lẽ anh Nguyễn Mạnh Dũng ở bên Dũng Starter, nếu mà anh nói về cái này thì là tuyệt vời nhất, bởi vì tôi xin chia sẻ nhanh với mọi người là anh Dũng và một cái đồng sự của anh Dũng đã có một cái bài viết rất là chi tiết về cái chứng cứ trong tố tụng trọng tài, và anh có đăng cái này lên trên cái nó gọi là Academia. Thì tôi sẽ cố gắng chia sẻ cái này trên mạng để cho tất cả mọi người cùng tham khảo. Thì đấy là một cái tài liệu tôi nghĩ là đối với Việt Nam thì đấy là tài liệu nó gần như là chi tiết, rất là chi tiết về cái vấn đề chứng cứ mà trong cái bối cảnh thực tiễn của Việt Nam. Việt Nam thì hiện nay chưa có một cái khái niệm gì về chứng cứ ở trong cái luật của trọng tài của chúng ta. Tuy nhiên chúng ta có khái niệm về chứng cứ ở trong cái bộ luật tố tụng dân sự, và cái chứng cứ này thì nó sẽ, theo chúng tôi hiểu thì nó sẽ chỉ có relevant với lại cái tố tụng ở tòa án thôi, chứ nó cũng không hoàn toàn khớp với lại tố tụng trọng tài. Thì cái chứng cứ ở đây nó được định nghĩa là tất cả những cái gì mà có thật, được đương sự và cơ quan tổ chức giao nộp cho tòa án trong quá trình tố tụng, và tòa án thu thập theo trình tự thủ tục tố tụng của bộ luật tố tụng dân sự. Tuy nhiên là tôi cũng xin nói lại một lần nữa để cho mọi người rõ là đối với Việt Nam thì cái bộ luật tố tụng dân sự không phải là lúc nào nó cũng áp dụng mà một cách dập khuôn vào trong cái tố tụng trọng tài. Bởi vì tố tụng trọng tài thì chúng ta sẽ phải dùng cái luật trọng tài, nó sẽ hơi khác một chút với lại ví dụ như luật Anh chẳng hạn, là cái luật mà tôi đang hành nghề. Khi mà chúng ta có cái tố tụng trọng tài thì nó có một các cái vấn đề gì mà nó cần phải dẫn đến thì người ta sẽ refer luôn đến cái CPR, tức là cái tố tụng mà tại tòa án, và người ta sẽ nói cho chúng ta biết là lúc nào thì chúng ta dùng cái tố tụng tại tòa án và lúc nào thì chúng ta không dùng, mà chúng ta có quy định riêng. Nhưng về cơ bản thì tố tụng trọng tài ở nước Anh hoặc là một số các nước khác, Singapore thì chúng ta sẽ hỏi thêm Timothy, nhưng mà về cơ bản thì tôi thấy là nước ngoài thì nó sẽ là giống nhau. Nhưng mà còn ở Việt Nam thì hai cái tố tụng này nó không nhất thiết là giống nhau, nghĩa là ở tòa án thì nó có thể khác và tại trọng tài nó có thể khác. Cái IBA rules, cái bộ nguyên tắc của IBA về cái thu thập chứng cứ ấy, thì nó đã ra đời. Cái phiên bản đầu tiên của nó là cái phiên bản hiện nay của nó là phiên bản 2010. Thế tuy nhiên là đến tháng 2 năm 2021 thì người ta giới thiệu cái phiên bản mới là năm 2020. Cái phiên bản mới này nó còn rất là mới, và cái phiên bản 2010 thì đã được sử dụng rất là thường xuyên bởi tất cả các trung tâm trọng tài lớn trên thế giới. Ví dụ như là ở SIAC chẳng hạn thì nó đang được sử dụng gần như là cái bộ nguyên tắc của trọng tài này đang được sử dụng nói chung ở trên toàn cầu là nó khoảng 48%, và ở tại Úc thì người ta dùng đến 90%, tại châu Á là 57%, và tại Singapore thì nó khoảng 80%, và ngay cả tại Trung Quốc thì nó cũng phải chiếm khoảng hơn 40%. Đấy là theo cái báo cáo của trường Queen's Mary năm 2015. Thì theo những cái thông tin như vậy, chúng ta có thể thấy rằng là cái số lượng người mà biết về IBA rules rất là nhiều, và họ nắm về cái bộ nguyên tắc này cũng rất là chắc. Có đến 73% số lượng người được khảo sát thì họ nói rằng là họ đã thấy cái quy tắc IBA này đang được sử dụng trong các cái thực tiễn của arbitration. Và vì vậy cho nên là chúng ta ở Việt Nam có thể nó là mới, nhưng mà thế giới thì nó đã rất là quen thuộc rồi. Và cái nguyên tắc để lấy chứng cứ này nó là như thế nào thì tí nữa chúng ta sẽ tìm hiểu thêm. Thế nhưng mà tại sao Việt Nam nó lại là mới? Bởi vì là trong cái thực tiễn xét xử của VIArb ấy, là cái tổ chức trung tâm trọng tài lớn nhất của Việt Nam, thì nó cũng chưa có cái quy định gì mà liên quan đến việc là chúng tôi có sử dụng hay không sử dụng cái IBA cả. Nó để chống trong cái việc này. Và cái quy định liên quan đến cái chứng cứ ấy, thì trong cái về nghĩa vụ chứng minh thì đương nhiên là cái nghĩa vụ của cái bên mà muốn đưa ra cái yêu cầu, nghĩa vụ chứng minh là anh sẽ phải chứng minh cái yêu cầu của mình bằng cách là anh nộp các cái chứng cứ, đúng không ạ? Thế nhưng mà có những vấn đề mà liên quan đến những cái rất là quan trọng của IBA, ví dụ như là cái hoạt động production of document, tức là hoạt động cung cấp cái tài liệu chứng cứ mà do bên này yêu cầu bên kia, thì thực chất là nó chưa được quy định rõ. Nó không có cái quy định cụ thể trong cái quy định của luật Việt Nam cũng như là của bộ nguyên tắc của VIArb. Trong thực tiễn của VIArb thì có một số các trường hợp tôi đã thấy đã từng dùng cái reference schedule. Cụ thể là trong một cái case chúng tôi đã từng tham gia, thậm chí là cũng mấy năm trước, không phải bây giờ, thì nó chỉ được sử dụng thứ nhất là trong các trường hợp các vụ trọng tài quốc tế, chứ tôi chưa nhìn thấy vụ trọng tài Việt Nam nào dùng đến cái reference như là cái IBA cả. Còn khi dùng đến trên quốc tế thì thông thường ấy, cái lý do nó được sử dụng là bởi vì các trọng tài viên đều là các trọng tài viên nước ngoài, hoặc là ít nhất là 2 trong 3 cái trọng tài viên là trọng tài viên quốc tế. Thì trọng tài viên quốc tế thì automatic đối với một vụ kiện lớn mà có cái giá trị mà cao và nhiều các cái tài liệu chứng cứ thì họ sẽ luôn luôn muốn sử dụng IBA, và họ cũng muốn sử dụng cái reference. Tí nữa chúng ta có thể nói chuyện một chút về cái reference schedule. Thì cái IBA rules cũng như là cái reference schedule là nó match với nhau, nó tạo ra thành một cái cơ chế rất là smooth, rất là dễ dàng để có thể lấy được tài liệu. Và cụ thể ở đây là cái cách thức để các bên yêu cầu tài liệu của bên còn lại. Thì cái này nó hơi lạ lẫm đối với cả các luật sư Việt Nam cũng như là các trọng tài viên Việt Nam, bởi vì là trong hệ thống tố tụng của Việt Nam thì nó không có cái cơ chế này, nó không có cái cơ chế là bên này lại đi đòi tài liệu của bên kia, mà nó chỉ có một cái cơ chế ở trong luật, đó là các bên sẽ tự đưa tài liệu ra, và thứ hai là các bên sẽ không phải tự đưa ra mà do yêu cầu của hội đồng trọng tài. Nếu mà hội đồng trọng tài yêu cầu là tôi thấy cái này chưa rõ, đề nghị anh cung cấp chứng cứ về cái này, thì lúc đó cái bên đó sẽ đưa ra, đúng không ạ? Thì đấy là cái thực tiễn, nó cũng bắt nguồn từ việc là chúng ta xuất phát từ hệ thống civil law, hệ thống dân luật, cho nên là chúng ta cái cách tiếp cận của chúng ta đối với cả cái vấn đề chứng cứ nó là như vậy. Và chúng ta vì vậy cho nên là chúng ta không có quen thuộc với các cái hệ thống reference cũng như là cái IBA rules, và chúng ta cũng không quen thuộc với một cái khái niệm. Một tí nữa chúng ta sẽ cùng với cả ông Timothy discuss với nhau, đó là cái khái niệm inference. Nếu như một bên mà không đưa tài liệu thì bên còn lại sẽ làm gì, đúng không ạ? Và hội đồng trọng tài có cái punishment, có cái gọi là hình phạt gì cho cái việc là anh được yêu cầu đưa tài liệu nhưng không đưa không, đúng không ạ? Quá trình production đấy thì nó sẽ cũng là một cái câu hỏi đặt ra rất là lớn. Đấy là cái background sơ bộ về cái tình hình hiện nay ở Việt Nam. Và lát nữa thì tôi sẽ cùng với cả ông Timothy trao đổi về một cái vụ kiện. Chúng ta có một số vụ kiện đã từng nhắc đến IBA ở Việt Nam, nhưng trong đó thì có một vụ kiện rất là nổi tiếng, là vụ kiện mà có lẽ những người làm trong giới trọng tài hay cũng biết, đó là vụ kiện của Vĩnh Sơn Sông Hinh. Và cái vụ kiện này thì đã được đưa lên public cái bản án của không phải bản án, cái quyết định về việc hủy phán quyết số 11 năm 2019 của Tòa án Nhân dân thành phố Hà Nội. Thì nó có liên quan đến một điểm mà cái hội đồng trọng tài trong trường hợp này đã sử dụng IBA rules. Thì chúng ta sẽ dành một cái phần tương đối nhiều của cái buổi hôm nay chúng ta discuss về cái đó, và chúng ta xem xét xem là chúng ta sẽ trao đổi xem là liệu Việt Nam có những cái vấn đề gì, những khúc mắc gì khi mà sử dụng cái IBA rules này hay không, và nếu có thì chúng ta sẽ vượt qua cái đó bằng cách nào. Đấy là toàn bộ cái thông tin sơ bộ. Và trước khi chuyển chuyển mic sang cho ông Tim thì tôi cũng xin nhắc lại một lần nữa, quảng cáo một chút về VIArb. Đó là một cái tổ chức tư nhân đầu tiên ở Việt Nam mà mang tính đào tạo và nghiên cứu về trọng tài. Và cái tổ chức tư nhân này thì đã được thành lập bởi 7 cái thành viên sáng lập, trong đó bao gồm rất nhiều thành viên là các cái chuyên gia cũng như là các trọng tài viên cũng như là luật sư trọng tài đang practice ở các công ty luật lớn ở Việt Nam về trọng tài. Và chúng tôi mong mỏi rằng là các cái thông tin của chúng tôi đưa đến với tất cả các cái khán giả là các cái thông tin mà nó hữu ích cho tất cả chúng ta để improve, để gọi là tạo ra được một cái môi trường hoạt động trọng tài chuyên nghiệp hơn và phù hợp hơn với lại thực tiễn quốc tế. Chính vì vậy cho nên là chúng tôi đã tổ chức những cái chuỗi sự kiện như là cái series này, cũng như là một cái khóa học mà chúng tôi đã hứa hẹn từ lâu đối với tất cả các quý vị. là sắp tới vào tháng 6 thì chúng tôi sẽ tổ chức cái khóa học đó, và cái thông tin về khóa học thì sẽ được cung cấp rất là sớm. Nhưng mà bật mí với tất cả các bạn, các anh chị là chúng tôi đã liên hệ được với một số các cái trung tâm trọng tài rất là lớn ở trên thế giới, ví dụ như VIArb chẳng hạn, để họ hỗ trợ và hợp tác để cùng đưa ra cái chất lượng cao nhất cho cái khóa học sắp tới này. Thì nó cũng là cái khóa học đầu tiên rất là dài kỳ, khóa học kéo dài gần 3 tháng và có 9 module, cho nên là rất mong là khi mà đưa ra cái chương trình này thì các quý vị sẽ đón nhận một cái nhiệt tình. Now I will pass on to you, Tim, to discuss the general topics of the IBA rules. I have introduced the background of the Vietnam situation, and a little bit about what IBA is, and of course about you, about your background. So now, please, the floor is yours, Timothy.
Thank you very much, Tony, and thank you for inviting me to speak this evening on the IBA rules. They are, of course, very popular in international arbitration and have been for very many years. But in order to understand why that's the case, I thought it might be helpful to take a step back and look at where these sorts of rules fit into the wider process of arbitration. Tony, I don't know whether it's possible for you to show some slides.
Can you share the screen from your computer? Yes, or do you want me to share your slides?
If you're able to, that would be great.
Sure, yeah, I'll do that.
So the IBA rules are just one set of rules that are frequently used by parties in arbitration. And the reason why they're used is because of the way in which parties put together the procedure for any given dispute. So if I can turn to the next slide and talk a bit about the background to how these rules have become so popular. If you are in a court, whether it's in Vietnam or in Singapore or really anywhere else in the world, the procedural rules that the parties have to follow are usually set out clearly in the rules of court that apply. But in arbitration, we don't have the same set of rules. There is no overriding one set of unified rules that applies to any international arbitration. So how do parties and arbitrators go around deciding what procedural rules are to apply? And there are really three ways in which this is done. The first overarching set of procedures is defined by the law of the seat. So where the arbitration is seated, it could be seated in Vietnam, it could be seated in Singapore. The law of the seat, so the arbitration laws of that country, will provide some framework for the procedural rules that apply. What also will refer to the procedure will be the rules of arbitration that have been chosen. So you could have the ICC rules or the VIAC rules or the SIAC rules. And each of those rules will make some reference to the procedure to be adopted in an arbitration. And then the third layer are other rules or other guidelines that may be adopted by the parties. So if we could go to the next slide, please, Tony, slide one. I can talk a little about each of these things. So I've talked about the three stages of the law of the seat, the rules of arbitration and the further guidelines. So if we can go to the next slide, I'll talk about the law of the seat. So the law of the seat is one place where the parties will look to see what procedure governs the arbitration. And most laws of the seat give the arbitrators a very broad discretion to determine the procedural rules that will apply. So, for example, in Vietnam, as in Singapore and any other country that has adopted the United Nations UNCITRAL model law, Article 19 of that law will apply. If we go to the next slide, I've put what Article 19 says, and it's headed Determination of the Rules of Procedure. And it's very, very broad. It says, subject to the provisions of this law, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. And then it says, failing such agreement, so if the parties don't agree on what procedure they want to use, the arbitral tribunal may, subject to the provisions of this law, conduct the arbitration in such manner as it considers appropriate. And the power conferred upon the tribunal includes the power to determine the admissibility, relevance, materiality, and weight of any evidence. So if you're conducting an arbitration in Vietnam or in Singapore, for example, then the laws of those countries provide that the tribunal can, in theory, decide what procedure to adopt. So that's the first stage, that's the law of the seat. The next stage is the rules of arbitration that the parties have adopted. So if we could go down, Tony, to slide 4. The parties may have chosen the VIAC rules. That's probably appropriate for this audience. They might have applied the SIAC rules, the ICC rules. All of those rules will make some reference to how the arbitrators and the parties are to prepare evidence, how they're to present the evidence, and how the evidence is to be tested in an arbitration. But when you look at those rules, what you will find, quite similar to the law of the seat, is that the rules are quite broad and not very descriptive. So if you look at the VIAC rules, they have 3 important provisions, rules 18, 19, and 20, which confer on the tribunal the power to verify the facts of the case, how the parties may collect evidence, and that they have the right to summon witnesses to give evidence at a hearing. The SIAC rules are even vaguer. They provide that the tribunal is to conduct the proceedings in such manner as it considers appropriate. And then it also says it may determine the relevance, materiality, and admissibility of evidence. Those are the words from the model law that we saw a moment ago. And it also clarifies that the tribunal is not required to apply the rules of evidence of any applicable law in making such determination. Now, the reason why that is there is to make it clear that if you have an arbitration governed by, let's say, Chinese law, and the agreement in dispute is governed by Chinese law, the arbitrators don't need to apply Chinese rules of evidence in determining the dispute. What that rule provides is that the tribunal can apply whatever rules it thinks are appropriate. So if we could turn to the next slide, you might wonder, why are the law of the seat and the rules of arbitration so vague when it comes to the procedure for the arbitration? And the reason for that is not because someone has made a mistake and has overlooked things, but because it's designed to ensure flexibility in each individual case. So there are differences that will arise in different parts of the world when you conduct an arbitration. For example, parties coming from a civil law tradition like Vietnam may want to prepare and present evidence in a way that's very different from the way parties in England might do that. And the rules are kept broad so that in each individual case, parties can decide how they want to prepare their cases. But there can be a complication, and that complication is when parties from different traditions face each other in an arbitration. So you might have, for example, a party represented by Vietnamese lawyers on one side, and you might have Singaporean party and lawyers on the other side. And in that situation, what do the parties do? How can they come to an agreement how to prepare and present evidence? Now, that is the background to why the IBA rules were drafted just over 20 years ago. If we can go to the next slide. Because the law of the seat and the rules are silent as to procedure when it comes to evidence, over the years, parties and their representatives have come up with different ways and different sets of guidelines to make the arbitral process consistent and predictable and easy to follow. And there are different sets of what have been referred to as soft law to try to guide parties and tribunals. The IBA rules on taking of evidence are probably the most important and most popular set of rules that have been used in international arbitration for a very long time. There are other sets of rules that parties could also choose. For example, something called the Prague Rules on the efficient conduct of proceedings in international arbitration. One other aspect of arbitration that's become popular in recent years is where witnesses give concurrent evidence. In other words, they give evidence at the same time, sitting next to each other in a proceeding. And so the Chartered Institute of Arbitrators have produced guidelines for what's called witness conferencing. So there are all these different guidelines that have been proposed over the years, which parties can choose, and the tribunal can choose, depending on the case. And they may not even use all of those rules. They may, for example, take a little bit of or the important provisions in the IBA rules, but they don't adopt other parts. The idea of all of this is so that the parties and the arbitrators can work out what is the best procedure for their particular case. Now, over the years, the IBA rules have proven to be extremely popular. And the reason for this is that they have tried to address some of the differences between the civil law and the common law traditions. If we could look at the next slide, please. So there are, I think, three key areas where the IBA rules have grappled with different approaches to giving evidence. The first is document production. If you come from the US or common law countries like the UK, Hong Kong, Singapore, Australia, lawyers are used to a process of what's called discovery, where lots of documents are exchanged between the parties. That is to be contrasted with civil law, where often in the courts very few documents are exchanged, or parties simply produce the documents that they wish to rely on. And the IBA rules have tried to find a balance between those two. So at one extreme, you have the US federal rules of discovery, which requires parties to exchange a great number of documents between each other, usually at great expense. And the other extreme, you may have a civil law tradition where parties exchange very few, if any, documents. The IBA rules try to find a balance between that, and we'll see how they do that in a moment. Another thing that arises typically between the civil and common law tradition are differences as to admissibility of evidence. So, for example, in the common law, we have this idea of privilege, the idea that certain communications between a client and lawyer are protected from being produced in an arbitration or in court proceedings. And the civil law has a similar concept when it comes to secrecy. Another area of documents which are usually withheld from production in an arbitration or in common law litigation are those which are described as being without prejudice. And that's very much a common law concept, and it relates to usually discussions between the parties that may lead to a settlement of their case. And the idea is that if parties are to communicate openly about possible settlement, they don't want an arbitral tribunal or a court to see those communications because it may impact on the perceived strengths or weaknesses of their case. And again, the IBA rules seeks to address this idea of admissibility of evidence, not just in relation to those points I've just mentioned, but admissibility generally. And then the final area of difference that the IBA rules looks at is evidence at a hearing. So at the trial where evidence is heard, again, one of the big differences between the common law tradition and the civil law tradition is that in the common law tradition, witnesses will typically be examined by the lawyers for the other party, and they'll be tested on their evidence and shown documents and asked questions about those documents. Whereas in the civil law tradition, as I'm sure you're familiar, typically those sorts of questions of witnesses will be asked by the judge and not by the other party. So again, the IBA rules looks at these sorts of differences. So if we can go to the next slide, you can see where these different areas are found in the IBA rules. So these are really the key features of the rules. So there's the question of document production, witnesses, the evidentiary hearing, which I mentioned, and admissibility of evidence. So those are the key features. And I'm going to look quite briefly at those because I think the detail of it's not important, but I just want to highlight how the IBA rules has approached these. So if we look first of all at the next slide on document production. Document production is really trying to be a mix between common law discovery and the reliance-based production of documents by parties in civil law. And what the IBA rule says is that parties may produce documents that they wish to rely on, and they may also ask the other party to produce documents if they feel that they are relevant to the issues that have to be decided and material to the outcome of the case. And the idea behind having this two-stage test is to make the document production phase much narrower than you would see in the courts of England or in New York. So it's trying to be a balance between lots of document production through a discovery process, and on the other hand, just producing documents that you rely on. So that Article 3 of the IBA rules provides this mechanism to try to balance those two extremes. On the next slide, we can see how the IBA rules deals with witnesses. So when witnesses give evidence in the common law, they typically prepare a witness statement, and then they give evidence at a hearing where they are cross-examined by the lawyer or lawyers from the other parties. And that is really the way in which the IBA rules envisages hearings to take place as well. So there is a slight balance in favor of the common law approach if you were to use the IBA rules. Similarly with expert evidence, experts are expected normally to prepare an expert report. The experts may be asked to confer, so if you have competing expert evidence, the two experts may be asked to speak and work out what they agree and disagree on, and they may then give evidence at a hearing and be cross-examined by the parties' lawyers. So witnesses are an area where the IBA rules tend to lean more in terms of the common law tradition of disputes. If we can look at the next slide, then how does the hearing itself play out if you use the IBA rules? It's very important that the tribunal is in control of the hearing, but the way in which witnesses give evidence is, again, something that will be probably more familiar to common law lawyers than civil lawyers. So there'll be a process where witnesses will give evidence when they're asked questions by their own party's lawyer. Then they'll be cross-examined, and they may then be given an opportunity to answer some further questions from their own party's lawyer at the end. And those three phases are known in the common law as examination in chief, cross-examination, and re-examination, or in the American phrasing, direct testimony, cross-examination, and redirect. One interesting feature of the IBA rules is that it clarifies that a party may themselves give evidence, or a representative or an officer of a party may give evidence. And again, if you come from a civil law tradition, that sometimes is not allowed in the court system, because it's assumed that a party giving evidence on behalf of themselves is going to be biased, and therefore the value of their evidence is limited. Again, in the common law, we don't really take that view. And so once again, you see the IBA rules are very slightly leaning in towards the common law way of doing things. And the final area where the IBA rules have some guidance for parties relates to admissibility and assessment of evidence. So it's Article 9 on the next slide. And what this provides, what Article 9 provides, is that the tribunal shall determine, it will decide the rules for determining whether a document can be produced, in other words, admitted into evidence. It can decide whether it's a relevant document, whether it's material, and what weight to attach to it. Is it an important document, or should the tribunal attach no weight to it? And Article 9 provides that the parties would be entitled to ask the tribunal to exclude and not look at certain evidence. And the grounds on which the party may apply for that are those which are commonly found in the common law. So, for example, privilege, or without prejudice, or confidentiality, something which is much broader, or on the basis that they are simply not relevant or material. So that's a quick look at what the IBA rules look at. And as you will have seen, there is a slight preference for the common law way of doing things. And these rules have been adopted or used in some way in international arbitration across the world now for over 20 years. And there has been a few years ago a sense that maybe parties may not always want to do that. They may not want to adopt a more common law style process. And so a few years ago, a group of lawyers and law firms in Eastern Europe, where there are mainly civil law countries, they drafted and published an alternative to the IBA rules called the Prague Rules. And those Prague Rules are intended to tilt the balance a little bit more in favor of the civil law. And so what they provide, for example, is that the arbitrator will lead the questioning of witnesses rather than the parties. The arbitrators will have a much more active role in deciding what documents should be produced. And even the tribunal will decide which witnesses to call. So a very different approach. But what it shows is that it's really up to the parties to decide what is the best way that they want to shape their procedure. And when we step back again and look at what the framework is for presenting evidence and testing the evidence, then you have the law of the seat, you have the rules that the parties have chosen, and then in the gap that's left to determine evidence, parties typically use the IBA rules, but they could use the Prague rules, or they could come up with their own version, although that's quite unusual. So that's really the context in which the IBA rules and really how they've become so popular in the past 20 years.
Thank you, Tim. Very brief but very interesting highlights of the IBA rules. And from what you have presented, I think the IBA rule seems to be trying to balance the approaches from a civil law perspective and from the common law perspective, but it's a little bit left wing to the common law side, right? And that is why we have the discussion of maybe some alternative approach. I think from my own experience, when I see how the VIAC arbitration is conducted and compared to some modified version in VIAC, and of course, if we go to arbitration in SIAC or ICC or Hong Kong IC, we'll see a real difference in the way that the evidence is requested, produced, and I think we do not touch so much on the witnesses, which is another world of difference between the common law approach and the civil law. At least as far as I understand, there are clear different approaches in accessing the documents that the parties are holding. From a Vietnam perspective, we are used to the way that the litigation process of producing the documents are made. Usually the court will decide which documents to be requested to the parties. And even if they want to have some information from a third party, maybe the requesting party will have to do through the court and not to the other side. So there is not much discussion between the parties on what they expect to receive from the other side or from a third party, or how these documents are provided. It's pretty much the court or the tribunal control process. And the arbitrators in Vietnam, they are not very experienced in, or they do not have the knowledge in the IBA rules way of doing. So what they will do is they read the documents submitted, and if they find something not clear, they will just make a request. And another features that we can see is from, for example, from VIAC, the role of the secretary of VIAC is very important. Everything that the tribunal wants to do, the documents that they want to request, they will make through the secretary. If you join these VIAC cases, you learn this difference. They are very different from, for example, a SIAC case, where there's no support from the secretary of SIAC. If the tribunal is too busy or it's too much documents to be handled, then the tribunal will ask the party if they allow the tribunal to appoint the secretary, particular for the case. Yeah. So my question to you is really that we have two different practices, and the key difference here is the way that the documents are produced. But if Vietnam want to open our arbitration industry to the world, we have more and more international arbitrators in our panel. More and more arbitrators and counsels, advocates want to join the practice in Vietnam and want to do arbitration. How do we harmonize this IBA approach and the domestic, more civil law style? Do you think that for you as an international arbitration lawyer, how difficult do you find it to approach a market like Vietnam from your IBA background?
Yeah, this is a very interesting issue because the reason why the international arbitration world has become so accustomed to the common law way of doing things, if I can put it like that, if the influence of the IBA rules has been, is very much a common law influence. The reason for that is really rooted in the growing popularity of arbitration through common law countries. I mean, you particularly look at the England, for example, which has had a very long history of arbitration, and as that has gone global, as it were, as common law countries have adopted it, then what's happened is that the ways of doing things, the ways of resolving disputes, has been very heavily modeled on the experiences of those lawyers, of those disputes lawyers. So because a lot of arbitration has been influenced from common law lawyers, they have just transported their common law understanding into arbitration. And that's really why it is where it is now. However, and that's the tradition I have grown up in. However, I think that the Prague rules are a good example of there being some greater awareness that that's not the only way to do things. I think that we have to be very careful in just assuming that because the IBA rules are so popular, they are the best way of doing things. That is certainly not necessarily the case. There has been a huge amount of criticism in recent years of the document production process under Article 3 of the IBA rules, in that some people feel that it has become so much more reminiscent of discovery that it doesn't really meet that attempted balance between the civil and common law. So it's a historical thing. The reason why the IBA rules are popular is historical. It does not mean to say, I think, that Vietnam and other countries who are now embracing arbitration as a means of attracting foreign investment and a means of resolving disputes, it means they have to abandon what they are used to and just adopt these unfamiliar ways. Of course, it's a give and take. People who are interested in doing arbitration in Vietnam, it's important that they understand the IBA rules. It's important that you know where it comes from and how it works. It doesn't mean to say that you don't want to also bring in your own way of doing things. So, for example, if you have a dispute between a Vietnamese party and a Chinese party, both civil law traditions, there's no reason why they should adopt the IBA rules and try to cross-examine a witness which they're not familiar with just because that's the international standard. And I think that it's going to change. I think that actually common law lawyers like myself are going to have to get a lot more familiar with how things are done in the civil law tradition. And I've had that experience. I did an arbitration in Switzerland a number of years ago, which was quite heavily directed by a very experienced Swiss arbitrator, who of course comes from an inquisitorial background, and ran the procedure in a way that was quite unfamiliar to me in many ways. And it ended up being a blend of the inquisitorial process and the common law in a way that I think meant it was very successful for the parties involved. One of the parties was from a common law tradition, one was from a civil law tradition. And I think he balanced those two things very well. So I think that it's important that that people listening and watching this get that familiarity with the common law process. But I don't think it means that it's the only way to do things. And as we develop, certainly in Asia, I mean, in Asia, there are many more civil law countries than there are common law countries. And although you've got places like Singapore and Hong Kong, which are quite dominant and have been very successful, again, that's a historical thing. Hong Kong and Singapore have had a good head start, but countries like Vietnam, Indonesia, China, they will be catching up. And as their influence grows, I expect that the way in which lawyers in those traditions have come up will have a greater say in how they want the procedures to be run. So I think we may find there's a genuine striking of a balance between the common civil law, whereas I think the IBA rules has been, as you said, it's been moved slightly to one side in favour of the common law. But the beauty of arbitration is that each case is different as more people come to it, and each tribunal is constituted with different parties. They can all have their own say. And I'm certainly seeing much greater debate in cases that I'm involved in, where a party from a civil law tradition is now saying they want things done in a certain way, particularly trying to clamp down on what they see are abuses of Article 3 in the document production system, IBA rules. So I think we are all in for change.
Yeah, that's very interesting. I had attended an event last year in IBA. Actually, it's organized by IBA, I think July last year during the COVID-19. And it was quite amazing that the IBA itself tried to put some comments or some discussion on the alternatives. Of course, it's very sensitive because IBA, of course, it wants to promote the IBA rules and not rules like practice rules or anything else. But they are open to discussion, and I think it's a little bit disappointing for me that the new IBA rules as I have seen, is not fundamentally changed. The way that they shift a little bit to balance the Asian style of way, the Japanese, the Korean, Vietnamese, a lot of countries in Asia are more civil law oriented. What is your comment on the new rules that has been adopted just a few months ago?
The new rules, I wouldn't say they're really new. I mean, there are some little changes here and there. They have, I think, improved some of the language where it was maybe a little bit unclear before. But there is nothing really in those rules that are a big departure from what was there before. I mean, certainly there is no big change in terms of Article 3 and document production. There's nothing groundbreakingly new that makes them of a different sort of application than they were in 2010. So I think what you might be saying is that has there been an opportunity lost to more fundamentally revamp those rules? My understanding is that wasn't really the purpose of those revisions, but it wouldn't, it would seem to me that is something that may be worth looking at. And the fact that there was this promotion of the Prague rules because there was a feeling that really things could be done in a very different way does suggest that there is some appetite for a different way of doing things. And of course, the parties don't have to adopt the IBA rules. It's not a requirement. So if they think that the IBA rules are too common law centric, then they can just, they can do something else. And I think that the challenge, though, is that the IBA rules are so often cited. I mean, in almost every arbitration, there is a question as to how parties will present evidence and test evidence. And almost without question, both parties just adopt the IBA rules without further thought. So, are the Prague rules a counterbalance to that? They may be, and I certainly understand that they have been popular as a framework in some civil law countries, because again, if you look at what the Prague rules do, they are promoting a very civil law approach. It's very much focused on the arbitrator ruling having control of the process. There is not this emphasis on witnesses and they're oral evidence. There's a much stronger emphasis on the documents, which is, I think, if you come from a civil law tradition, that's something that's very familiar to you. So, if you're a Vietnamese counsel and you're involved in the case against Indonesian party, I can understand why those rules may be more attractive to you because they're more familiar to you. You will know your own strategic avenues you can play within that tradition that we as common law lawyers, wouldn't necessarily know. So I think it's a case of, as more civil law lawyers in this part of the world start doing arbitration on the international stage, hopefully they'll have that understanding of what the IBA rules are, but will also be voicing their own alternative ways of doing things.
Yeah, I guess we are a little bit out of time. I will move on to the next question, which is a very interesting one, and I hope that we will have some insight of it. In one of the decisions of the court that I mentioned before, there's a very interesting decision, decision 11, 2019, by the Hanoi People's Court. And in this decision, I just try to translate it. I have the decision here. The decision of the court is that the tribunal considered the IBA rules, even on the background that IBA rules is not compulsory in this arbitration. And the tribunal referred to the IBA rules and believe that the tribunal has the power to explain and to amend the rules of VIAC, especially Article Rule 25. The tribunal was seen not to refer to the evidence provided by the respondent because they apply the IBA rules. So the decision, the court believed that the tribunal neglect and ignored the evidence of the parties based on the IBA rules is not accordance to the evidence and the documents presented under the Article 56.2 of the commercial arbitration law, and the reference to the IBA rules to limit the documents allowed to be submitted and reviewed and considered in the arbitration proceeding is not reasonable. Therefore, the court accepted the request to set aside the award. This is a very serious decision, and the implication of this, I think, is not to accept the IBA rules if it's where it is considered against the rules of the VIAC. And I personally, I think there's some technical wrongs in this reasoning, but it shows the attitude, the general attitude of the court when they look at a foreign source of the soft law. They consider it as part of the international law that Vietnam is not ready to accept. So do you think that in this context of the case that I have just mentioned, do you think that Vietnam can develop two different pathways for arbitration, one for domestic and one for international? Because international arbitration still follow the general rules, and if the ICC has a seat of arbitration in Vietnam, there's no way that the Vietnamese authority can say that this is the IBA and you can't apply. That is, in the eyes of the authority, it's a foreign proceeding. But if domestic we are still very concerned about these international soft laws that limit the ability of a party to submit some documents. Yeah. Do you have a comment on it?
Yeah, it is not uncommon for courts in different countries to adopt a different approach to domestic arbitration on the one hand and international arbitration on the other. In some countries, they are just treated as the same. So, for example, in the United Kingdom, in England, there's no distinction. In Singapore, for example, there's a different regime, one for domestic arbitration, one for international arbitration. And although the differences have narrowed a lot over the years, the reality is that the courts are able to look at and scrutinize a domestic arbitration and its process more closely than it would an international one. So if the Vietnamese courts are adopting or could be adopting one path for its domestic arbitration, one for its international arbitration, then there is certainly a lot of precedent for that in other parts of the world. And there could be lots of reasons why the courts may want to do that. For example, they may feel that it's important that they continue to have oversight over a younger jurisdiction and matters that involved Vietnamese domestic issues, whereas it would sit back a little bit more and be more deferential for international arbitration. That's an approach that has been taken by some of the jurisdictions. So that might be one way of describing and explaining the approach that the Vietnamese court has taken in that case. I mean, if you just look at Article 19 of the model law, which does form part of Vietnamese law, as far as I understand, you might think that the courts have gone into that discussion and that decision about the adoption of the IBA rules, perhaps more in a more interventionist way than it might have done in an international arbitration. But I can certainly say that looking at the development of other arbitration jurisdictions around the world, including Singapore 25 years ago, these sorts of, if I can put it like this, bumps in the road are very common. Vietnam is as a jurisdiction, as we all know, it's growing hugely. The amount of investment coming into Vietnam and the idea of it being such an attractive place to do business, it's going to generate disputes, and it will take time for people just to get used to how you resolve them in different ways, including arbitration. So it doesn't surprise me that there'll be this sort of case that tries to where the courts try their best to find the right answer, and particularly when they're dealing with something which is going to be unusual to them or something they're not experienced before.
Yeah, thank you. I think we had 10 minutes over time, but I think the answer is very interesting. We can look at the examples of South Korea, for example. They have a very big domestic arbitration, and they have separate development for the domestic. And they also have the international arbitration, very strong international arbitration. All the Korean parties, they go all over the world and have their arbitration team, their in-house, and the lawyers from Korea. Now they are as good as any common law arbitration lawyers. So we hope that we will be able to develop some sort of international capacity. And of course, for that kind of arbitration work, we will need to be familiarized ourselves with the IBA rules. And we can't set the rules differently for the arbitration, because it's just, as you said, so popular. Everyone just accept it and adopt it. But from a domestic side of view, there might be some other elements that we can still think about. For example, the VIC arbitrations without the IBA rules, they are still doing very well in the last decades. So I think there's no yes and no answer in this. But a true thing is that when we get more international, we need to know more and learn more about the IBA rules and how it works in the international forum. Thank you very much, team, again for joining us this live talk show, and I hope to see you again in our training courses. Okay.
Thank you very much for the invite, Tony. I really enjoyed our discussion.
Yeah, thank you very much, and also thanks for all the audience that are watching us on YouTube, and I will share with you the full slides of team after this. Yeah, thank you, team, and have a nice weekend. Thank you, everyone.